right. I see a hand raised already, and I haven't even. Yes, please, absolutely. Go ahead. And I think, yep, we've got a mic for you.
Can you hear me?
Yes.
Okay. The two questions that I had, the first one is, we work out of El Paso County, and we've had a record number of felony cruelty cases this year, like more than usual. And we've noticed we're having, I guess, like some pushback from our DA's office in particular about felony cruelty. We're getting told a lot that if there's no documentable injury to the animal, then there's no felony has been committed. So I guess I kind of wanted to ask your opinion on that, because I know like in the law, like dangerous animal clearly specifies there has to be injury. The cruelty one, to my knowledge, does not. And with these ones too, like I'm talking, we've got the actual incident happening on video.
Well, the tricky part, I think, is that when the charging DA takes a look at something, the standard that they are looking at is proving something beyond a reasonable doubt to a unanimous jury of either 6 or 12, in the case of a felony of 12. So there's the question of, do we believe this happened? Yes, probably is the answer, the clear answer in the majority of those situations. But then, can we prove it? Do we have enough evidence to meet our burden of proof? Can we prove it beyond a reasonable doubt to a unanimous jury of 12? That's a lot higher than just, do we think this happened? In the civil world, the standard is preponderance of the evidence, which is just more likely than not, this happened. So when you're dealing with that high, very high standard of proof, that could be where the DA is saying, I think we're gonna have a bigger chance of conviction if we keep this in misdemeanor territory. So there are a lot of factors that go into that charging decision. It could just be they don't think they have enough evidence to prove it to a unanimous jury beyond a reasonable doubt. It could be, taking a look at this person's history. They decide that this may be a first offense, and this is just the right thing to do. They do have that discretion. There could be a lot of factors that go into it, but probably the primary thing at play is that really high standard of the burden of proof. If you think about how hard it is to get anyone in a room to agree on anything, even like pizza toppings, you can think about what it might look like for a jury to deliberate and unanimously agree on all of the elements of a crime. So that could be what they're thinking. But
Okay.
I don't work in their office, so I can't speak to their motivation in every situation. But that's, in my experience, probably the hurdles that they're coming up against.
Okay, thank you. I had one more quick
Yeah.
question. We were kind of talking about the needlessly killing. Is there any kind of statute that would protect someone for, let's say, like euthanizing their own dog, humanely euthanizing their own dog? Let's say, 'cause if someone wants to, maybe out in the county, so they're not having the unlawful discharge of a firearm within city limits. If they want to shoot their dog, they do it humanely, but they just, we're tired of the dog. Like we had a lady just do that. She shot and killed her dog because she was tired of the dog chewing up her furniture.
That's an interesting question, and I think it would probably come down to whether the DA could prove needlessly killed an animal. If they were just tired of the dog, let's say it just barked a lot and they found it annoying, that probably wouldn't meet the standard of needlessly. But if it would have been inhumane to keep the dog alive any longer, then I think you can prove that it wasn't a needless killing. I would argue that there would even be a need for that type of killing in that situation. But I think it would come down to that. It would hinge on that word needlessly. which there could be some gray area, like a lot of these situations. All right, so we're going to launch into impoundment, which is a fairly big topic. So your authority would come in under 18.9.204.5, where a commissioned agent has issued a summons and complaint for a misdemeanor violation under this statute. In conjunction with your law enforcement partners, you may be able to take that dog into custody and place it into a public animal shelter where there is a warrant from law enforcement. So you can be law enforcement's partner and assistant in effectuating that seizure, but know that you will need a warrant. And so your law enforcement partners are going to be the ones actually authoring that search warrant, and then the warrant to actually seize the animal itself. Cost of care. This is something that DAs don't run into a lot. So if you have this situation come up, it's good to be able to talk through it with your DA. I did not see very many of these at all, and attorneys that are in the criminal context, they see money and numbers and dollar signs, and they're like, oh my gosh, I don't know what this is. But it's actually not that hard. So you can help educate your DA a little bit about what a cost of care hearing is for. Basically, it is to determine the reasonableness of costs of care that are incurred by the impoundment facility, whether that's a shelter or some other facility. And it basically includes, basic costs of food and shelter. It actually does not cover veterinary expenses that are beyond, just the most basic. So to prevent the disposition of the animal by the impound agency, by providing for the animal's care and provisions for at least 30 days, the defendant has to basically come to the hearing able to pay that amount right after the hearing when the determination is made by the court. And then the payment has to be renewed 10 days prior to the previous payment's expiration. So this is a continuous process where they have to continue covering the payment of the cost of care. Within 10 days after the impoundment of the animal, the owner or custodian may request a cost of hearing by providing notice to the district attorney, and then the hearing shall be held within 10 days of that request as set by the court. It will be the court's determination whether there was probable cause to seize the animal in the first place, and then the reasonableness of the costs. And I think most impoundment agencies are going to have a significant upper hand in these hearings, especially if you have a pro se defendant, which in a lot of these cases you do, meaning they aren't represented by counsel. They're not going to have kind of the savvy or know-how to really challenge this issue of reasonableness. As for something like food, it could be any brand of food, whether that is like Kroger store brand or premium dog food. Brand is not an issue. Where it might be a glaringly unreasonable cost would be, specialty grooming or specialty agility training or really specialized physical therapy. Things like that probably would not fall under that reasonableness standard, but that gives impoundment agencies quite a bit of leeway, and they would probably have the upper hand at a lot of these hearings. Most courts, I think, are going to sign off as these costs being reasonable, barring something that is really glaringly obvious. And then in terms of determining the probable cause for the seizure of the animal in the first place, this is where having a warrant is really handy, because if you already have the warrant that authorized seizure of the impounded animal, you don't even have to prove anything more on that front at hearing. You have already basically proved that there was sufficient cause for impoundment. So that basically cuts out a whole evidentiary hurdle at that hearing to just say, Judge, there was the warrant. That's already in the court's record, and I don't have to present any further evidence on this front. And so the DA can then really tailor the hearing to just the reasonableness of the costs, which makes it easy. As far as sales of impounded animals, the proceeds are first applied to the cost of the sale, followed by the care of and provisions for the animal during impoundment, including any costs that weren't covered by the defendant. If the defendant is found guilty, the remaining proceeds are paid to the impound agency. If the defendant is ultimately found not guilty, any remaining proceeds from the sale of the animal are paid to the owner of the animal. And notice must be provided to the owner at least 6 days prior to the sale. Another hypothetical here. Tell me what you think. Is this defendant responsible for these costs while impounded? The impounding agency provides daily physical therapy, specialized grooming, specialized training for all animals in their care. Is this something that the defendant would be responsible for? No. Very good. That's a softball. They would only be responsible for whatever portion of that went to the basics: food, shelter, very basic medical attention, nothing specialized. All right, has this defendant committed the offense of owning a dangerous dog? A person is out walking their hunting dog, and the dog attacks a chicken in a neighbor's unprotected yard. The dog is under their control, but the dog is not on their property when the attack occurs. Thoughts?
Oh, my bad. So the yard's not protected, but the owner still allowed the dog to trespass onto someone else's property, and then that resulted in the death of their pet.
Yep, that's exactly right. So even if their neighbor doesn't have a fence protecting their chickens, the dog owner is still the one responsible here for the dog's conduct. Yes.
Grab the mic. So this is, oh wow, that's loud, sorry. So this has come up in our jurisdiction because we get a lot of chickens killed. Chickens are not domestic animals nor livestock. How does that apply?
Well, I don't know that you could say they're not livestock.
Under the CRS, they're not considered livestock.
Well, I think it would still be considered injury to property.
Okay.
Unfortunately, that is a much lower offense, but it would still be a petty offense. Good question. So changing the hypothetical a little bit, what if a defendant is out, I'm calling them a defendant, but we'll say person for now, is out walking their 70-pound dog when a smaller 20-pound dog runs off a neighbor's property, attacks the defendant dog, and then the defendant dog, the big one, ends up killing the little dog. I think I'm hearing mostly no's. That would change the scenario here. We have an affirmative defense. The dog was provoked and was defending itself and its owner. So that's one exception that you should be mindful of. All right. In this one, the defendant has 2 dogs in a dog fight, but but he stops the fight before any injuries occur to either animal. Does that matter? Let's say for entertainment, he arranges this dog fight, but he stops and intervenes before any injuries to the dogs occur. Does that matter? So he is still engaged in animal fighting. Whether the dogs or whatever animals are injured in the course of the fight doesn't matter. And so getting into that grayer area of encouragement, what if the defendant did not own either dog, wasn't present for the fight, but told several of his friends to go to the dog fight via Facebook? Yeah, I would say that counts as encouragement. What if the defendant let their friend borrow their car to transport the dogs to the dog fight, but it turns out he didn't know the dogs were going to engage in a fight? Then no. And so this is where you get into that gray area. Maybe he says he didn't know, but other evidence contradicts that, and ultimately the prosecuting attorney doesn't believe him when he says he didn't know. So that could be a judgment call based on the credibility of the witnesses involved. And then what if no money was involved? What if this was just for entertainment, no one paid any admission fees? Does that matter? That's right, it doesn't matter. It could be for monetary or entertainment. Is cost of care the same thing as restitution? You guys are good. It is not the same thing, although sometimes there could be an overlap if an impoundment agency is seeking reimbursement for any costs of care that weren't covered by the defendant. Basically, they wouldn't be allowed to double dip. They can't seek cost of care and restitution for the same expenses. That would be a windfall for them. So there can be overlap in that sense, but usually they are not considered the same thing. Restitution is really designed to make the victim of the crime whole, and cost of care just covers reasonable cost to care for the animal while in the custody of the impoundment agency. Restitution can be sought after a conviction enters, whereas cost of care hearing actually happens fairly early on in a case after the impoundment of an animal, and that happens before any conviction or plea has moved forward or entered. So that takes place much earlier on in the process. Okay, Fourth Amendment. The Fourth Amendment is a huge body of law, so this is a lot of ground to cover in a very short period of time, but I'm going to try to distill it down to its essential points. This is the Fourth Amendment of the Federal Constitution, also enshrined in the Colorado Constitution. Basically, this gives people the right to be secure in their person, houses, papers, effects against any unreasonable search or seizure. No warrants shall issue except upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So a couple short sentences that have really big implications. So what does that mean for you as BAP agents? You do have the authority under Title 16 and essentially working with Title 35. You may issue a criminal summons and complaint to enforce a misdemeanor violation of Title 18, Article 9. Again, when you're dealing with something that may be criminal, even if you think it's a misdemeanor, always best practice to get law enforcement involved, because there are many situations with these crimes, as I've sort of illustrated earlier, that a misdemeanor can evolve into a felony, and it's not always apparent at the outset of an investigation whether it's going to remain a misdemeanor or become a felony. So always good to get your law enforcement partners involved. You may gather necessary evidence, including the interview of a witness or an animal owner, but When gathering evidence would require the execution of a criminal search warrant, that's off limits for you guys. That's where local law enforcement has to step in. That's where your authority ends, and they need to take over. So the Fourth Amendment, much of the case law, if you've ever read any of it, really the touchstone of it is this expectation of privacy, because those few sentences of the Fourth Amendment are pretty vague. The way a lot of this analysis will play out is, what steps did someone take to protect their privacy in a certain situation? Were they, out in broad daylight, or were they in the privacy of their home? Really different expectations of privacy are going to attach based on the facts of each scenario. So essentially what Colorado case law has found is that a person has a legitimate expectation of privacy from unreasonable government intrusion, whether that is a home, an apartment, a motel room, or a tent. So it can be, how this looks on the ground could vary. And automobiles are a big one in terms of exceptions. You're going to be looking at, was it in the main compartment of a car? Different expectation of privacy than the trunk of a car when the trunk is not visible. Different expectation of privacy than a locked glove compartment. What about under a seat? These are all of the really gray area, subtle distinctions that officers have to make when they're deciding whether they need a warrant and whether they can continue on in their search. Few exceptions to needing a warrant, especially for your purposes, are going to be the open fields doctrine, the plain view doctrine, abandoned places, and consensual encounters. So we'll start with the open fields doctrine. What is an open field? That is like the most vague description I could think of, but basically case law has found that it includes unoccupied and undeveloped areas outside the curtilage of a home. The word curtilage is not something that you hear in everyday conversation, but that basically means the area surrounding a dwelling. That could mean the backyard and the front yard. If there is a yard, it could mean a grassy area just on the side of someone's driveway, between the driveway and the fence. It could mean an alley behind a house where someone keeps their garbage cans. It's a vague term, and it's going to be really fact-specific when you actually encounter and observe a particular dwelling. But an open field would be sort of one step beyond that. If there's a field that's clearly not occupied, it's not developed, it doesn't have any dwellings or fixtures on it. For example, if there was a swing set on it, I don't think you could really call it an open field. If there's a trailer on it or a barn, you're probably not in open field. It would also matter how close you are to someone's dwelling, but generally speaking, it would be the unoccupied and undeveloped area that's beyond the curtilage. So again, here's some case law that interprets what curtilage means. When we're law students sitting in our first year of criminal procedure and this word is thrown at us, we're like, oh my gosh, what on earth does this mean, and who would ever use this word? But it becomes really important, especially in your investigations, because this is oftentimes where you're going to encounter animals. But it is essentially the area immediately around a dwelling. Went one too far, there we go. And so plain view can work in conjunction with the open fields doctrine, because essentially objects in the plain view of an officer who has the right to be in that position to view the object, and that's a really important phrase, are subject to seizure without a warrant. So think about how this might work in conjunction with the open fields doctrine. If an agent is in an open field, it's clearly not a protected space. There's maybe even not a fence. Even if there is, if it's clearly an undeveloped, unoccupied area, and there's something that's clearly visible from that position in the open field, you've got plain view. And that's an exception where you wouldn't need a warrant. Abandoned property is really tricky. It could be a property that is temporarily vacant, has fallen into disrepair. Maybe there's some construction that started but didn't finish. None of that rises to the level of abandoned property, so I would be very careful proceeding on to a property that you think is abandoned. I would do a lot of homework before you do that. Talk to the neighbors. Have they seen anyone coming or going? If there's any surveillance footage in the area, check that. Talk with your local law enforcement partners. See if they know anything about that area. But yeah, that's a high, the courts are very reluctant to determine that something is truly abandoned. It's a pretty high bar. So proceed carefully if you think something is abandoned. So a consensual encounter, and now we're getting more into talking with people versus just going onto property. A consensual encounter would be really any time where an officer, and that would include you, approaches a civilian, and the civilian, based on a reasonable person standard, believes that they are free to leave. So let's say you go on scene, there's someone standing next to the barn where you hear animals inside that maybe need attention. Someone is standing there and you approach them and just say, "Hey, what do you know about this barn? What do you know about these animals?" You're talking in a conversational tone. The mood of the conversation is relatively light. The person's movement is not restricted at all. You're in consensual territory. This is going to apply to probably most of your witness interviews, especially if people are fairly cooperative. You're sort of in the information gathering stages. You don't necessarily have a suspect in mind yet. Consensual encounters are probably the majority of the encounters you're going to have with people. In terms of who can give consent to come onto a property, this can get tricky in situations where there is a tenant who occupies a part of the dwelling, or you have a guest staying there, and they say, "Sure, come on in, why not?" But it turns out that they don't actually have authority to give that consent. So if someone answers the door and you ask if you can come in, first figure out who they are, if they live there on a permanent basis, and if they actually have the authority to let you come inside. If they're a guest or they only have access to a certain part of the house, such as a tenant in a basement apartment, they probably don't have consent. They probably can't give you consent to come in. So in terms of what parameters you would have to abide by when interviewing someone who may be a potential suspect, someone who you believe has perpetrated some crime against animals, what you have to watch for under the 4th, 5th, and 6th Amendments are voluntariness, that this is going to be a voluntary interaction. You know, there's no coercion or, there's not harassment or torture or anything like that. That's probably not going to be an issue, but voluntariness under the 5th Amendment, a right to counsel under the Sixth Amendment, and then kind of a hybrid of those is where Miranda would kick in. The difference between an investigation and an investigation is really just information gathering. You're talking to any witnesses on the scene. These are probably going to be consensual encounters. An interrogation would be where you're actually trying to elicit an incriminating response from someone who you believe has perpetrated a crime. Miranda is a creation of case law, but we've all heard the litany of rights that someone gets under Miranda, and most officers even have a card that they read it from. So we all know, how that sounds when it's read. It's on TV all the time. But for Miranda to kick in, someone needs to be in custody and they need to be being interrogated. So custodial interrogation. And you have to have both. One or the other is not enough. So custody is a whole analysis under the case law, and so is interrogation. So we'll get into that. And then the Fifth Amendment protects against involuntary statements, so no waterboarding. But it has to be voluntary, no promises or coercive government action. An example of this might be if an officer said, well, if you don't talk, we know where your family lives, or something. If there was some very obvious threat, that would not produce a voluntary statement. It would probably lose on Fifth Amendment grounds. Custody is determined by the reasonable person test, and it's whether a reasonable person under the same circumstances would believe that they were free to leave or disregard the officer's request for information. Again, one of those really vague, not very helpful definitions, but factors are always helpful. And so under the Matheny case, which came out of Colorado, these are some of the factors. These are not exhaustive, so there could be more. But examples of how you would go about analyzing whether someone's in custody would be who's present during the interrogation. Do we have one officer or do we have 5? The officer's tone of voice and general demeanor. Are we talking conversational or really obviously stern, giving really strict commandments? The length and mood of the interrogation. So is it a 5-minute conversation on the side of the road, or is this an hours-long interview? Where it took place, the space in which it took place. If this is at the police station, for example, is this in a room that has doors and windows? Was the door open or shut? How big was the room? Who was in the room? These are all really important questions. Was the officer in plain clothes? Was the officer in a uniform? Was the officer armed? These details really matter when you get to a motions hearing and the defense is trying to throw this out on Miranda grounds, saying you didn't read my client their Miranda rights and they were in custody. These are the questions that you might be asked if you're on the stand. So best practice would be to record, use body cam. I don't know how many of you guys have body cams, but that's always the best practice so that you're not relying on memory. You can just play the video and say, see, this was a very easy conversational tone. This is certainly not custodial. Right to counsel. Basically, what you should know is that if anyone ever says they want a lawyer, stop talking to them. Just stop. Once they invoke that right, basically any further questions that relate to the crime, the answers are not going to be admissible in court. You could continue asking them maybe some very administrative type of questions like what's your address and phone number, but no more substantive questions after they invoke their right to counsel. Now, the suspect may reinitiate conversation. Let's say he says, I want a lawyer, and then 10 minutes later he says, no, you know what, I want to tell you my side of the story. I'm ready to talk. Courts, I have found, are still fairly reluctant to say that a suspect has reinitiated conversation. So be very careful about that. I would say if they want to reinitiate conversation, give them their Miranda rights again, and have them waive the Miranda rights in writing. In writing is always going to be best practice. So what happens what are the consequences of an illegal search or an illegal seizure or an interview that was found to have violated Miranda or someone's right to counsel? Is that the exclusionary rule kicks in. It means that any evidence obtained illegally is inadmissible at trial. So if you get a great confession out of someone, but they were in custody and they were clearly being interrogated and you didn't give them Miranda rights, that confession isn't coming in. So as great as that, beautiful 20-minute confession might have been, the jury's never going to see it, which means that the chances of conviction are much lower. So that's the end game that we're looking at when we want to make sure that all of this evidence is obtained in compliance with these. We want to make sure that it's admitted at trial, that the jury sees it, that they can actually consider all of this really important evidence that you've spent so much time gathering, and that we can get our conviction and hold this person accountable. The other sort of caveat of the exclusionary rule is that even where the evidence itself might not have been illegally obtained, if it falls under fruit of the poisonous tree, it's still going to be excluded. So this is a really hard concept, I think, even sometimes for lawyers to really wrap their heads around. But once one illegal thing happens, one, let's say, illegal confession is obtained, and they say, oh, by the way, the body's in the trunk of my car. Well, guess what? Since that body was found based on an illegal confession, the body's not coming into evidence either. So anything after an illegal search, seizure, confession, everything down the line stays out. So it's a big deal. And you could, the DA's office could lose a lot of evidence at trial if that happens. So that's sort of what to keep in mind in terms of what the stakes are. So we're going to have another hypothetical about whether this defendant was in custody at the time of this interview. The defendant is being contacted because of complaints of animal neglect in his home. BAP agents received reports from the neighbors, and so they respond to the defendant's home. They knock on the front door. The defendant steps out onto his porch to answer questions. During questioning, one of the officers reaches behind the defendant to pull the front door shut. The tone of the interview is fairly conversational. The defendant refuses to answer some questions and gets annoyed, but ultimately the officers continue talking with him for about 20 minutes until they leave. Thoughts on whether this was custodial? Yeah, I would say no in this scenario. Now, if we change a few facts, that could change. Let's say the agents repeatedly ask the defendant to answer these questions. He refuses. He says he wants a lawyer, and one of the agents corners him in a corner of his porch and refuses to let him get past him. That could be considered custodial. Anywhere where you have restricted movement, or if the officer had their weapon on them, anything that could be perceived as making the defendant believe that he was no longer free to leave, that could mean that he was in custody, in which case Miranda would apply, and anything he says that's not under Miranda would not be admissible at trial. So, based on this scenario, did officers commit an unconstitutional search? So let's say there is a complaint of excessive dog barking from neighbors. This house has a carport in the back that is out of view from the street. Officers respond, or agents respond to this home. They hear the barking, but they can't see the dog from where they are standing on the street. So they walk up the driveway and behind the house, and they see that the dog is chained to the back of the carport and is badly injured around his neck. Have the officers committed an unconstitutional search at this point? Let's hear a yes and a no. Any reasoning? Yeah. The dog is not in plain view.
Thank you. If they couldn't see it from where they were legally allowed to be on the sidewalk or street, and they had to walk down someone's driveway to the backyard, then that person would have a reasonable expectation of privacy for having something in that part of their yard.
Yeah. Excellent reasoning. Anyone with a different point of view?
So I'm going to say no on it.
Okay.
Kind of based on factors, if the dog sounds in distress, you might have exigency to go back there. Okay. Also with the driveway, is it where the front door leads to? Is it a different door they use? You have a reason to be there like the mailman would. Then plain view, seeing the dog with the chain, you have exigency, save its life. So that's my no.
Both really good analyses there. In this case, I would say without some very obvious signal that the dog was in distress, only that the dog was barking, there's probably an unconstitutional search here. I think it could change the analysis if it was clear the dog was in distress. If the dog was whimpering and sounded injured, that could definitely change the analysis. But here, the officers have gone behind the carport, so they're in the curtilage of the house, essentially like a side yard is sort of what I'm imagining, but that would be the curtilage. It's out of view from the street, so we're not in plain view. Once they've entered the curtilage, there is an expectation of privacy there, and they have committed an unconstitutional search. So a better way to have done this would be get local law enforcement involved and get your warrant. Usually, especially now that a lot of jurisdictions can do swearing a warrant over the phone, and they have an electronic way of doing that, they can actually get it pretty quickly. So definitely get a warrant in this situation. Did the officers have authority to search the house? So let's say officers respond to a call of animal neglect at a home. Officers knock on the door and there's no response. A person walks out from the backyard, tells the officer they're staying in the basement apartment for a few days. Officers ask if the homeowners are around, and the person says no, but the front door is usually unlocked and they can go wait inside. The officers enter and see a clearly undernourished dog. Thoughts on whether officers had the authority to be there? Yeah. Very likely the answer would be no here, because they're not the homeowner, they don't have access to the entire house, so there's probably not going to be a clear authority for the guest to give consent for a search, and since they were not lawfully present in the home when they observed the dog, even though that dog was in plain view, we're already at the poisonous fruit, and everything down the line stays out at trial. All right, thank you for bearing with me through a lot of information. Questions, comments, thoughts, feelings?
I wanted to go back to talking about the second subsequent conviction.
Yeah.
Because I had something recently where we were really confused. Somebody's on probation for obviously a prior offense. Horses don't have any water. Another thin horse. We're talking about a possible second offense, but do they file it as a felony, or is it a second conviction becomes a felony? Like, do they serve a misdemeanor,
So
or do they file?
They would file it as a felony because that second conviction would become essentially the felony. So that would be filed as the felony.
Okay.
I know that's confusing, but yes.
Yeah, we got really stuck on the word conviction. So the sheriff's office was like, we don't understand if we serve them or if we do a direct file, because that word conviction confused everybody. So
Yes, I think that would be filed as a felony.
I can't wait to tell them that. Okay.
Yeah. No, good question.
So let's say going off the second convention, they haven't been convicted of the first crime yet because they haven't had a court date yet. Oh, they didn't go to their court date for the first one. Anyways, if they get convicted of the first one, could they change the second one to a felony?
Yes, they could.
Okay.
Yep. Looks like we have one in the back. Yeah. No, keep them coming. These are great.
Okay, this question I have about the cost of care, specifically under cruelty. If you are impounding a dog or an animal, let's say under what let's say we're going to call it suspected cruelty at the moment. You have a dog that you know for a fact, okay, the femur has been broken in half. Nobody can give you answers as to how. You know that there's somebody in that house that has been convicted of doing the same thing in the past with another dog. At this second, you can't prove it. Nobody's getting vet care. They haven't. They're not going to. So you're not going to leave the dog there. Because, I mean, you suspect that it's going to be in danger if you leave the dog there. So you impound the dog under the cost of care statute, but you haven't issued charges yet. You just want the dog out while you're conducting your investigation. Is there like a set timeline of how long you have to file charges or return the animal?
So, under the statute, the defendant may request the hearing within 10 days of impoundment, but that's really for the defendant. That's not a timeline that you have to look for. That's something that if they want their animal, it's on them. So, no.
If they're not going to pursue the hearing, so obviously that, because then there you'd sort it out right at the hearing, but if they're not going to do it for whatever reason, then yeah, kind of trying to figure out how long you have to complete your investigation to issue charges or to return the animal if you're not going to.
Right, yeah, that's a deadline that applies to the owner or suspect at this point and not to you. Yeah. All right, terrific.
Thank you so much.
Thank you. It's so good to be here. All right. Oh, yeah.
Okay, so.
Thank you
We're
for
gonna.
pulling that up.
Oh, hello. Okay, we're gonna take a 10-minute break. But really quickly, I know there was a question about chickens and definition of livestock. So under 18.9.201, livestock is defined as bovine, camelids, caprine, equine, ovine, porcine, and poultry. So just figured I'd provide that definition. Okay, so yeah, let's take about 10 minutes, and then we will come back for our last session that Taylor Peterson and Dr. Claire Vaden are gonna lead, and there will be animals there. So see you soon.